It's been a jam-packed, fun-filled day, and we want to add a little more to that. I think that we may have maybe the most timely session coming up here. In fact, for those of you who saw that rather long piece that FinCEN put out last Thursday, we have the FinCEN representative here who is going to impart words of wisdom upon us. Likewise, Clay Porter, who's joining us, comes from an extensive experience at the Department of Justice. So what I thought I would do is first let each one of our speakers give a little bit of background on themselves, and then we'll jump right into a whole host of questions. So I'm Carol Van Cleef, the CEO of Luminous Group, and a partner with LeClaire Ryan as a lawyer, wearing a couple of different hats. And I've been totally immersed in this field for a very long time. And today, this morning, you heard about the eGold case. I represented the eGold founders after they were prosecuted by the US government. So I've seen, they didn't go to jail. I will note that. But I've also seen the impact that that kind of action can have on a business model. Kevin?
Good afternoon, everyone. I am really excited to be here with you today. And I'm very excited to see an audience that's as thrilled about compliance as I am. It's very exciting, particularly this part in the afternoon. I work in FinCEN's enforcement division, where I do civil investigations of financial institutions for their compliance with the Bank Secrecy Act and the US's AML-CFT regime. In that role, we work a whole bunch of cases. For me specifically, where I come involved, I help supervise and oversee the money service businesses and casinos section with a bunch of colleagues. And that, of course, is where you get your wonderful intersection with virtual currencies. So I'm very excited to be here to talk to you about my experience there, some of our investigations, and some of our work there.
Thanks, Kevin. Thanks, Carol. And thanks, everyone, for being here. My name is Clay Porter. I'm a managing director at Navigant. I generally design AML and sanctions compliance programs for financial institutions. I left the Department of Justice in December of 2017, where I was the chief of the Bank Integrity Unit and the assistant principal deputy chief of the Money Laundering and Asset Recovery section in an acting capacity. In that role, I supervised all the bank, AML, and sanctions cases. And my last, one of the very first cases that I supervised when I became a supervisor was Liberty Reserve, and that's how I first became acquainted with cryptocurrency. It's great to be here, and I look forward to a great conversation.
Thank you. I think one of the biggest set of questions I hear, confusion in this industry is, what's the difference between BSA and AML? Can we go to jail for BSA violations? And how does this AML stuff come into play? So can you help clarify, Clay, what is Bank Secrecy Act? I'm sorry, Kevin, what's Bank Secrecy Act? Why don't I necessarily go to jail for Bank Secrecy Act? And Clay, from where you said DOJ, you put those cases together to send people to jail.
Well, it can be complicated in that because, so the Bank Secrecy Act is sort of a general term for a whole host of legislation and regulations that implement the US's overall anti-money laundering and countering the financing of terrorism regime. So it's a whole set of laws that sort of implement these standards in place. I should have led my talk off, since the name of this panel has something to do with going to jail. I do civil investigations. We can't send you to jail. So that's a bit of a misnomer in that sense, but I think Clay can sort of add on to that. We do civil investigations. There are civil and criminal implications for compliance with the Bank Secrecy Act, and there are sort of different ways of doing that. So from our investigations, the work that we do, that is usually a civil investigation, and that will usually result in some sort of fine or undertakings or something along the lines of that.
So when things veer away from the civil side and into the more criminal side, that's where the Department of Justice comes into play, of course. That's where the prosecutors, the FBI, the IRS show up. Now, what does that mean? Well, To violate the Bank Secrecy Act in a criminal manner, you have to willfully violate the Bank Secrecy Act. And what does that mean? That means that you knew you had a duty to have an AML compliance program, and you purposefully disregarded that duty and went ahead and did your business without having that program in place. That is a willful violation. So certainly there are, and that the criminal authorities have to prove that beyond a reasonable doubt. But quite frankly, and Kevin will talk about this, is that most of these cases, the AML cases and sanctions cases, are worked in parallel with the regulators. So FinCEN and the Department of Justice will be working in parallel. For example, almost every case I'd worked in the Department of Justice, I was on the phone with FinCEN, the DFS, and other bank regulators. So it's not just the DOJ off on its own.
Yeah, and if I could just add one thing to what Clay said, we also have a willfulness standard for civil violations, but it's a different standard than the criminal violations. So we're looking at reckless disregard for our willfulness standard there. And one of the things that's important to note that, and you'll see this on our enforcement actions on our website, usually in a footnote, it's willful blindness or reckless disregard, and you don't need to know the law. You don't have to demonstrate knowledge of the law to demonstrate willful blindness and reckless disregard for the purpose of a civil violation.
So I want to draw a little bit of contrast here. OFAC. If I violate sanctions rules, if I do a transaction with someone who's on the OFAC no-fly list, the SDN list, I don't have to really, no one has to prove willfulness, right? It's just if I've done the deed, I've violated the statute. This is different from what we're talking about in Bank Secrecy Act and AML, right?
From the criminal standpoint, it is a willfulness standard for sanctions violations.
But there is a strict liability standard for, I'm not going to go too much into OFAC. I know I don't want to speak for my fellow Treasury regulators, but there is a strict liability standard when you're talking about doing transactions with a designated person or jurisdiction. So there are going to be implications beyond just being a financial institution, as one of the earlier panels pointed out, that there is a strict liability standard for that.
And there's one other piece here that, again, I think to have everyone come on the same page, and that's 18 U.S.C. 1960. Could you explain to us what 18 U.S.C. 1960 is, and again, what kind of standard do we have to deal with there?
You want me to go from the criminal side?
Yeah, go ahead. I'll fill in.
Well, on the criminal side, 1960 is a criminal statute that you have to prove beyond a reasonable doubt. And it's basically either an unlicensed money remitter where you're not licensed by FinCEN, or you're moving dirty money. That's generally, it's criminally derived funds. That's the general basis for 1960. If you look at the Liberty Reserve case, you look at some of the other, some of the crypto cases, and even some money service businesses cases, they're typically charged in the criminal side under 18 U.S.C. 1960.
And there is a corresponding civil violation for that as well, and I think you can see that in both the BTCE case that we took, which again was parallel with the Department of Justice, criminal civil, and the most recent Eric Powers case that we did, where we cited someone for failing to register with FinCEN. That's a violation of the civil requirement, which is outlined in the Code of Federal Regulations. So there are civil implications. If you fail to register with FinCEN, you could be subject to a penalty of $8,000 per day of noncompliance. So that can compound pretty quickly in terms of what we can assess in terms of penalties. Similarly, if you fail to implement your program, you could be subject to a penalty of up to $55,907 per day per violation. So as you can see, that can sort of escalate really quickly.
And I don't speak for the federal government, but I can say that based on my experience, one thing you should be thinking about in your AML program, or if there's an investigation that you get wind of or you receive a subpoena, typically the AML program is not going to be looked at in a vacuum. They're also going to look at the OFAC program as well, because quite frankly, what we've heard and what we've seen is a number of smaller transactions coming in and out of various sanctions countries. The government is going to look at those closely because they can make that case based on a willfulness standard, willfully violating sanctions, and they'll also be looking at your AML program.
And I would just go one step further on that. You know, you have to think about it. You have a requirement in your AML program, if you're operating, to have appropriate internal controls and policies and procedures in place to prevent your money service business, for example, from being used to facilitate money laundering or terrorist finance. If you're accepting or facilitating transactions to OFAC prohibited jurisdictions, I would argue that you probably don't have strong internal controls or policies and procedures in that place. So there are still AML implications that could come from that. It's not going to be the same thing that OFAC is looking at, but there are broader AML concerns that can be looked at in that space.
That's a really good point. And by the way, online there is the Money Service Business Manual for AML Compliance Programs. You can get this online. And part of that includes having an effective OFAC compliance program as well. So it's really financial crime you're looking at. And one of the things that I've seen folks make mistakes about is that they silo their program. Their programs don't talk to each other. So their OFAC compliance program doesn't talk to their AML compliance program. So if you're doing some due diligence or KYC and you're not sharing that, that's going to be an issue. But having siloed programs really hurts your ability to look at your overall risk. You've got conduct risk. You have an overall risk of your business. And looking at them in snapshots undermines your ability to quantify and qualify that risk.
But one of the problems that I've seen, and some of this is historical, is that early on, especially in the banking world, the banks were combining their AML and OFAC programs together. And blending them in ways that wasn't allowing them to do the appropriate risk assessment and other factors. Some of that has carried over into this area, so there is a need to make sure that you're dealing with each of the sets of issues you need to in each area, but make sure that they're working together.
Yeah, I mean, I think part of the issue sometimes comes down to you have a BSA officer who's also your OFAC compliance person, who operates as everything in your compliance program because you're building your compliance program and it's expensive, right? And people are, well, can I just do it with this one person? Well, you really have to think about what your business model is, but most importantly, you cannot have an effective compliance program, and I mean AML and OFAC, unless you have an effective and thoughtful risk assessment. If you have not done your risk assessment, then you are flying blind. And when you're flying blind, that's when bad things happen.
And I would underscore, you know, Undersecretary Mandelker said this really well this morning. Your compliance needs to start from the beginning, and it needs to grow alongside your business processes. You need to periodically look at how your compliance program is growing to meet your business needs. And you need to look, similar to what Clay was saying, do you have the most appropriate personnel in this space? One of the big things that we see from an oversight standpoint is people will just appoint anybody and they're, hey, he's my compliance officer. Well, I have news for you. If you don't know about AML compliance and you don't know about this technological space and how it fits into that, you're going to have a really hard time having a compliance officer that can meet what you need to meet U.S. regulatory obligations.
That's a good point. When you look at transaction monitoring, right? Like, if you don't have someone in your compliance program who understands tracing on the blockchain, on a blockchain or whatever blockchain you're operating off of, you're really selling yourself short because you don't have an effective compliance program because you might not be able to see where the transactions are coming from.
I can do one better on that. If you are doing manual transaction reviews and you are processing hundreds of thousands of transactions every day, I would really, really like to know, and I mean this sincerely, please tell me how you're able to keep up with that and see all of the red flags or tools that exist in that space. To some degree, you know, transaction monitoring can be automated to some extent. It's all based on your risk-based approach and how you're building your risk assessment and your compliance program. But if you're not keeping up with the volume that you're doing and building your compliance program out and it's all manual, I promise you it's one of the first things we're going to notice.
Well, the manual issue is rather important because whether FinCEN was prescient 20 years ago when it wrote the regulations, became effective at the end of 2001, they said in there that you're supposed to have automated solutions or automated systems for compliance if you are dealing with automated, if your operations are automated. And we're talking back in the day of the small little mom and pop MSBs that didn't have any kind of automated solutions, but in this arena, we're pretty high-powered tech companies.
Putting on my other hat, if you're a casino, that's actually one of your AML pillars. There's an extra pillar. One of those pillars is actually use of automated systems and all available.
Well, and the automated systems is language that's in the FinCEN regs for MSBs, but often gets overlooked along the way.
Right, but it's, as we know, it's totally risk-based, right? So if you are an operation that does maybe 10 or 12 very large transactions a day, then it may be that you can do it manually. But to Kevin's point, if you're running, hundreds of transactions a day or more, manually it sort of strains credulity that you can actually do an adequate job and locate suspicious activity and file SARs on that suspicious activity.
And that's very much the case too when you move to OFAC. If you start checking manually the names against the list, you're going to see how taxing that is very quickly.
I mean, one of the things I think gets lost is that when the Department of Justice or FinCEN or OFAC issues a press release on an enforcement action, and it happens to be a bank or a corporate, folks that aren't in that specific industry say, it doesn't, I don't really need to worry about it. That's a bank. But the principles underlying those enforcement actions are very important. Take a look at the Banamex USA case. That is a bank case, but it talks about looking at transactions manually and how they could not keep up. And the government, it was issued a non-prosecution agreement, and they were fined, and there was a forfeiture because, and I think, and the regulators took action against individuals because they had decided they were going to stick with the manual system when they knew they couldn't keep up. They knew they couldn't do all the things they needed to do. So I encourage you to look at non-crypto related enforcement actions just to get a sense of what the principles of AML are.
And please, no, I think that's really astute, and I think John Smith on a couple panels earlier really hit this point about compliance through enforcement actions. Enforcement actions are a tool to learn what people have done wrong and how you can build your own compliance program to avoid those same errors. There's a reason why we publish these on our website, that we make them available. They're a tool for future compliance. What did this company do wrong? If you read the BTCE assessment that FinCEN publicized, it tells you a whole bunch of the errors that they had. It'll spell out, look, they did not do appropriate due diligence on transactions with mixers and tumblers. They did not do appropriate due diligence with respect to anonymity-enhanced cryptocurrencies. It's all in the assessment. It tells you the things that you need to do to build out and use and improve your own program.
So why don't we turn now to and talk a little bit about the FinCEN guidance, because that clearly has had a lot of people talking. I'm in a number of Telegram chats and have seen all sorts of questions raised over the last few days. The Undersecretary spoke this morning. I guess what would you say are the three highlights of the FinCEN guidance that came out last week?
If I can go big picture, I would say sort of three ideas. Consistency is the first one. The rules have been the same since 2011. The rules that affect this sort of space were first issued in 2011. We've been very consistent that the rules apply through the 2013 guidance, through subsequent administrative rulings, up to the guidance released last week. The rules are the same. I'd also say clarity. That's one of the big themes. What we try to do when we issue this is to provide additional clarity for questions we receive from industry, from regulators, about where they might need help understanding things. So that's another big idea. And then again, you heard the Undersecretary speak this morning, compliance, the other sort of issue. It's important to understand your compliance obligations and be able to successfully implement them so that you can prevent your financial institution from being taken advantage of.
And just to follow up on that, Kevin, I think that's the last one is for me is the most important, and primarily because you should be able to take this guidance and compare it to your own program and make sure that they're matching up. I can tell you when I used to draft subpoenas that I was going to, grand jury subpoenas that I was going to be sending to financial institutions if I had whiff of an AML issue. It often included certain FinCEN guidance relating to the issue that I was investigating. So then when I would get these emails that would sometimes be forwarding the guidance around, and I would get a sense of what people are talking about that guidance. Some folks were actually saying, in compliance, were saying, oh, we need to look at this. Can someone create a matrix? What are we missing? What do we have? And I've seen other ones where there's just a total, completely ignoring that guidance to their own detriment.
So, Kevin, you dealt with the issues from a macro standpoint. From a more micro standpoint, does the guidance deal with issues that have not necessarily been dealt with publicly before, but have been addressed in private letters with companies? I guess what would you say are the 2 or 3 highlights of those types of points that we would want to take away?
Well, I think, when you're getting, I think what you're getting to is some of the business model questions we get at the end, of the end of the guidance, where it sort of breaks down the application or how business models are, what their activity is and how that fits into the US AML regime. I would point to, dispelling some of the myths that, again, have been in place since 2011. We just re-articulated it. So, for example, you don't need fiat currency to be covered by AML. Virtual currency to virtual currency transactions have AML obligations under the US
And that
framework.
includes stable coins.
So stable coins, look, we're technology neutral. We don't regulate virtual currency. We regulate activity. So if you are using a stable coin for the purpose of money transmission services, as it's defined in the BSA, absolutely you would be a money transmitter. So that's one side of it. I'd also say, with the Eric Powers action and with the guidance, you can see we have very clear rules that peer-to-peer transactions, even small peer-to-peer transactions, may be covered by the Bank Secrecy Act and have AML obligations. And then I'd also point to the sort of larger picture that if you're a foreign located entity doing business in the United States in whole or substantial part, you may also have AML obligations. Again, none of those things are new. They've been in place since 2011. I think there are other things such as, particular issues with respect to initial coin offerings and with distributed applications that vary based on the business model, and to get into the very regulator-friendly term of facts and circumstances. But every step forward on that, where we can provide clarity, where we're getting questions, that's what we try to go for.
So on the whole or substantial piece with respect to foreign entities that are doing business in the United States, what is substantial? If I have 1,000 customers outside of the US and I have 2 in the US, do I need to register as a money service business?
I think we'd have to look at it on a case-by-case basis. I think that, if you look at the advisory we put out in 2012, FinCEN, FIN 2012 A001, it gives some particular considerations to take into account when you're doing business as a foreign located entity in the United States. Just remember, if you are, you have to designate an agent in the United States for records for service of legal process. That's a requirement.
And remember, AML, it obviously means anti-money laundering, but it also means money laundering.
Right.
So the federal government, through through 1956 A2A, which is Title 18, it's the one of the criminal money laundering statutes. It is what's called the International Promotion Statute. It was quite frankly my favorite statute because all I had to show, and not all I had, but the basis was that if money went to or from the United States had jurisdiction and could charge that matter. And jurisdiction is really a separate issue in terms of personal jurisdiction. If you're in U.S. territory and they get you, that's personal jurisdiction. There's no issue there. What I'm saying though is if you have a totally overseas operation, but you avail yourself of the U.S., you send money even once to or from the U.S. as part of laundering money, you can be prosecuted for that.
So our title is, how do you avoid or stay out of jail? What if I were to get a subpoena from the Department of Justice? How should I handle that? If I've had an exchange that's been operating for 3 years and maybe I've been registered for a year.
Well, as Kevin would say, it's a case-by-case basis. But what I would generally say is, if you get a subpoena from the Department of Justice, don't sit on it. Don't wait. Don't hope it goes away, because it's not. And you need to find yourselves very good criminal lawyers. But, you know, what I would suggest is, if you've been operating for 3 years without a program, it's not too late to start that program now. The Department of Justice has very clear guidelines on what are called the Phillip factors, or and those Phillip factors talk about remediation, and talk about the kind of compliance program you should have or be thinking about, and that's with the there's new DOJ guidance on compliance programs as well. All that is to say, it's never too late to start building that program. And it's also, when you have that subpoena in hand, it's very important that you are very responsive and thoughtful about your next steps.
And your compliance program will actually have a tenant required that has response to law enforcement requests as an element that's consideration for compliance with that.
So, Kevin, one of the issues we end up with is, or I hear often, is the IRS is supposedly the one examines, does a Title 31 examination, as they call, which is an examination under the Bank Secrecy Act of money service businesses. But we also are hearing more and more about FinCEN investigations. Could you explain to us the difference and maybe how the two of them work together? Yeah,
and there is definitely a difference. So FinCEN is not a very large organization, relatively speaking, for the US government. We're about 340 people, and we have responsibility for overseeing, you know, AML compliance in every financial institution in the United States. Naturally, that doesn't mesh as a one-to-one relationship there. So we delegate our authority to federal banking agencies, to the SEC and the CFTC, and also to the IRS for examination of money service businesses, casinos, and a bunch of other non-bank financial institutions like dealers in precious metal, stones, and jewels. That means that when someone comes to examine you, if you're a money service business, they're going to be IRS agents because they have more personnel in the field. Sometimes, and I've been on examinations myself, FinCEN will accompany the IRS on site to do exams, partially to learn from the company, partially to help train the IRS examiners so that they know what to look for and to build future compliance training manuals for the government. So that's one source of referral we get to FinCEN. We get referrals of egregious violations of the BSA from examiners. That filters up and we consider it. The other bucket are FinCEN proactive cases, where we use our own intelligence from the BSA or conduct our own proactive investigation and look at the conduct of a financial institution that poses potentially significant harm to the US financial system. That's where you get cases like BTCE, which was a proactive FinCEN investigation that then married up with the criminal investigation on the same side.
And on the BSA examinations for the IRS, the Department of Justice will seek those exams as part of its investigation. If it's investigating a company, a financial institution, will seek those exams and use those exams as part of the investigation process.
So you really don't want to be written up with any violations of law in those exams, because it establishes the case almost immediately for FinCEN or DOJ.
No, to be candid. Because there's two separate things here, right? So there is the examination and Kevin will speak to that, on how they're looking to see if the compliance program meets the various specifics of the requirements of a program. The DOJ will be looking at it generally. First off, the Department of Justice does not expect perfection. It never has, number one. And number two, mistakes happen. That's not the issue. It's when it's egregious, it's willful, and it's purposeful. That's when the Department of Justice steps in. The bank exams, the IRS exams are used for knowledge. Did the company compliance officer know that this was an issue over time? The fact that there may be a matter requiring attention, a box that was not checked, may or may not have actually effect on the criminal investigation.
And, you know, we would look for very much the same thing. We would try to use, getting dinged on an IRS exam, that's not the end of the world. You should use it as a checkup. The problem is that I'm over time. I'll finish that thought, though. The problem is that if you see a negative finding from the IRS and you don't do anything about it, and they come back and find it again, that's going to be a really hard question to answer.
Okay, one last quick question. Eric Powers' case was based on violations from 2012 to 2014. That case came out, what, 3-4 weeks ago? In 2019, we live in a real-time space here. Are we really supposed to learn a lot from that case?
I think so. I think that was the first case that we acted that spelled out the requirements of AML do not just apply to the big players in the space. They apply to peer-to-peer people as well, and that came out in advance of our guidance. So yes.
Okay. Well, thank you very much.